third or more, and that's from October 26th of 2024. Your indictment alleges you were previously convicted of driving while intoxicated March 27th of 2018, and then again May 18th of 2023. And how do you plead to that charge?
Guilty.
And are those two prior convictions true?
Yes.
And did you enter your plea of guilty and true freely and voluntarily, and because you did what they charged you with? I have here on the tablet some documents and have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Mr. Macon? Do you fully understand them? And do you understand if I follow the agreement? Good morning. What's the announcement?
Oh, I'm sorry, Judge. We filled out plea bargain rejection.
I don't see it yet.
It must be in the air.
Okay. All right. Let's go through that. Sir, you're Davin Kalina.
Yes, ma'am.
And Mr. Kalina, in cause number 24, DCCR 2432, you're charged with the third-degree felony offense of injury to a child, elderly, or disabled individual from September 27th of 2024. And what that means, sir, is that if you go to trial and you're found guilty, the range of punishment would be between 2 years and up to 10 years in prison. Do you understand?
Yes, ma'am.
And I have here on the tablet a document that you've signed with Mr. Kelly. This a plea bargain rejection that shows that the district attorney's office has made an offer if you wanted to enter a plea of guilty. And that would be to plead to the lesser included Class A misdemeanor, what, just an assault? Or
Yes, Your Honor, just an assault. And it would probably be refiled. We would
Okay.
put that as the rejection.
Gotcha.
And if we are, I think right now it's best to put it on the trial docket. I think we can prepare trial very quickly. If for some reason I am able to resolve it with that refile and some pretrial matters, I will do that. It will be off the school stock.
Okay, thank you. And so what the offer is for a 2-year deferred probation. You have every right to reject that and to have your case set for trial. I just want to make sure you understand what the possible consequences are and what your options are. Do you understand all of that?
Yes, ma'am.
And if it sounds like if there is something that gets worked out before that trial docket, then it'll get taken care of down the hall in a misdemeanor court. But I want to make sure you understand if that doesn't work out and you're still on this trial docket, that I won't accept this plea agreement once you're back here and set for trial. Do you understand?
Yes, ma'am. We understand.
Okay, so I'll get it set on the trial docket. Again, if something works out, just let us know. We'll get it taken care of.
We'll do that.
Right.
Thank you.
Thank you.
Yes, thank you.
Stay in touch with Mr. Kelly. He'll let you know when you need to be back and to which court.
Thank you, Judge.
Good morning, ma'am. Are you Ashley Sanders? And this is 24 DCCR 1650. Ms. Sanders is charged with theft of service. I think we've been waiting on
This is also
the audit. So everything's done as far as discovery, and now we've got the rejection, correct? So
Yes.
Ms. Sanders, you're charged with a second-degree felony offense of theft of service. And that's from February 1st of 2019, continuing through May 31st of 2023. And what that means, ma'am, is that if you go to trial and you're found guilty, the range of punishment is between 2 years and up to 20 years in prison. Do you understand? And I have here on the tablet a plea bargain rejection that you've signed with Mr. Kelly that shows that the district attorney's office has made an offer if you wanted to enter a plea of guilty. And that would be for a 10-year deferred probation. You would be required to pay any restitution back and follow rules and conditions of probation. You have every right to reject that and have your case set for trial. I just want to make sure you understand what the possible consequences are if you go to trial and what your options are, if you understand all of that. And do you want to reject that offer and have your case set for trial? Is there
Just to be candid with the court so that Ms. Sanders is aware, that offer obviously contemplated the court's authority to change the length of that and also a restitution hearing of sorts so that
Sure.
we can kind of figure out, if that's an appropriate amount of time, if the court thinks less is appropriate. I just didn't want her to feel, we put it up there at the top to give you that latitude.
And if y'all, would that make any difference? So I do want to make sure that after today, Ms. Sanders, you understand that once your case is on the trial docket, I will not accept this plea agreement unless there's new evidence that your attorney or the state's attorney discovers. Do you understand? And do you want to reject that and have your case set for trial? All right, we'll get it set on the trial docket and Mr. Kelly will begin preparation for trial.
Okay.
Thank you.
Thank you.
Good morning, sir. Are you Aaron Wars? And Mr. Macon, will your client waive the formal reading of the indictment?
Yes, sure.
Mr. Wars, in cause number 25, DCCR 1253, you're charged with the third-degree felony offense of driving while intoxicated, third or more, and that's from October 26th of 2024. Your indictment alleges you were previously convicted of driving while intoxicated March 27th of 2018, and then again May 18th of 2023. And how do you plead to that charge?
Guilty.
And are those two prior convictions true?
Yes.
And did you enter your plea of guilty and true freely and voluntarily? And because you did what they charged you with? I have here on the tablet some documents and have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Mr. Macon? Do you fully understand those? And do you understand if I follow the agreement?
This is the part most people underestimate. One plea doesn't just mean jail time. It can literally decide whether someone stays in the country or gets deported. At this moment, the stakes just jumped from courtroom to life-altering consequences. Did you catch how quickly that reality is delivered?
That you've made with the district attorney that you'll be waiving or giving up any right to appeal. And it looks like the agreement that you've reached is for a 10-year term in prison, but that would be probated for 10 years. You would have a $500 fine and be required to follow all of the rules and conditions of probation.
Yes, please. 10 days in jail starting this Friday.
I have to sentence him. He has to be sentenced.
Yeah.
I can't sentence him today. I have to get a pre-sentence report.
Okay.
So the 10 days will have to be after that pre-sentence
Yeah.
report. It's mandatory, but it won't start this week. So what'll happen, is that your understanding of your agreement though? Okay, and we'll talk about the 10 days in just a minute. Do you also understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law?
Yes.
State tenders number 1.
No objection, Your Honor.
It's admitted. Is there any evidence that Mr. Wars is not competent?
No, Your Honor.
All right, sir, I'm going to find that you entered your plea of guilty freely and voluntarily, find that you're mentally competent and understand the nature and the consequences of your plea, find sufficient evidence to find you guilty. However, I'm going to reset your case so that the probation department can do a pre-sentence report. That'll give me more information about you and your case, and then we'll come back later for sentencing. Do you have, as a condition of your bond, the auto ignition interlock device on your vehicle?
Thank you.
So you're not driving? Okay, I do want to make sure you understand that if you get a vehicle, you cannot drive any vehicle unless it has that auto.
Even after a guilty plea, the courtroom doesn't slam shut, it stretches the process out. Interlock devices, sentencing delays, probation prep. Every detail is being locked in step by step. So the real question becomes, is the punishment already decided, or is the hardest part still coming?
Interlock device on it. Do you understand? Right. And then that 10 days, again, when you come back for sentencing, that's when you'll either start it that day, or if you're working, then I would consider starting it a different day that weekend or something like that. So we'll talk about that at sentencing. On your way out of the courtroom today, you need to stop and talk to probation, and she's sitting at that desk right over there. Okay, we'll see y'all back at sentencing.
Okay, thank you.